Hello and welcome to this webinar, Right or Privilege, Privacy of Communications on the Internet. Before we begin, we acknowledge the First Nations people of each of the lands on which we meet and their continuing connection to land, sea and community. For me, I acknowledge the Bedigal people of the Eora Nation and pay my respects to their elders past, present and emerging. My name is Marina and I'm the National Convener of the Australian Society for Computers and the Law. We are delighted to co-host this event with the Allens Hub for Technology, Law and Innovation and Cybersecurity CRC. Today you'll hear from our distinguished panel, Rachael Falk, the CEO of Cybersecurity CRC, Ed Santow, Human Rights Commissioner at the Australian Human Rights Commission, and Professor Lyria Bennett-Moses, UNSW Professor of Law and Director of the Allens Hub for Technology, Law and Innovation. We encourage you to ask questions of the panel, and you can do so by using the Q&A function on your screen. Lyria, thank you for moderating, and now over to you.
Thank you very much, Marina, for that introduction. I would also like to acknowledge that I am here in Sydney on Gadigal land, members of the Eora Nation, and respectfully welcome all Indigenous people on lands around the country to this important conversation, as well as, of course, everyone on the call. I'd also like to thank the Cybersecurity CRC and the Australian Society for Computers and the Law for helping to organise this event, as well as the Australian Human Rights Commission for lending us the great Edward Santow. So there's a lot to talk about on this topic. There's been changes in how we communicate. Fewer people now use a traditional phone line, so the old idea of wiretapping looks a bit obsolete. Communications now increasingly involve a whole range of apps, promising different protocols in terms of encryption, deletion, and everything else. In light of all of that, I thought I might ask Rachael Falk to start us off with a bit of a history of the law in this area. Rachael.
Thank you, and thank you for having me on and inviting me on here today to talk with you and Edward. It is indeed a privilege, and I'd like to acknowledge the Ngunnawal people on whom are lands in which we are here today in Canberra. So why are we here and why are we talking about this? In the old days, where we used to have plain old telephone services, and they were run or governed and produced by what we call carriage service providers, Telstra, Optus, Vodafone. And this is probably back in the days where people like me, and I'm ancient, can remember that when you stood in the kitchen or in the family room with a fixed line and your whole family had to listen to the phone conversation. If there was no such right as privacy as a teenager, it was certainly having to stand in the family room while everyone listened to your phone conversation. But carriage service providers, and there weren't that many of them, were governed by the then, now, an existing piece of legislation called the Telecommunications Act 1979. And it was part of the carriage service licence and obligation that every product they produced, so from the old fixed line right through to these things when they were the size of house bricks, had to be interceptable. It had to have a capability for interception, and it could not be put on the market until it had that capability. And what that meant was intercept material was a very valuable piece of mostly criminal and others, but criminal investigations. And just as today, your fixed line, if you have one, can be intercepted, as your mobile service can, as well as could emails and plain old text. That was all working very well for everyone, and a regime where it was part of the licence obligation, which meant carriers simply could not refuse. It was a legal obligation, and if you like, a legal obligation and a licence to play in this country that you had to do that. There were obligations under Warrant, similar to today's regimes. You had to be a target, had to be target services, had to be subject to a warrant and a serious indictable offence. And so various services could be intercepted and intercept product produced. But what happened with the burgeoning of what we call the DSPs, what we'll call non-traditional carriers, so the over-the-top communicators, the WhatsApps, the phone calls that you can effect on WhatsApp, FaceTime, everything began to be taken off the plain old telephone line and run above, mainly through data. And what that meant was all the providers that offer those ranges of services we're not bound. We're not caught by carriage service obligations because their manufacturers were not carriage service providers. And gradually, since I've been involved in this area since 2012, the phrase going dark began to be used. And what that meant, and law enforcement agencies and intelligence agencies, what they meant is intercept product means it's light, it's captured, it's on the surface, it can be captured. When everything starts to go dark, you can't see the communication because it's encrypted. That means it can't be deciphered, can't be hacked easily, can't be read by others. And then we have end-to-end encryption, which means it's from the beginning of the message to the end. The one who makes it, one who receives it, can only understand that message or that call. So what it means in short is, and that's what Tola was getting, was there's a whole bunch of now we call non-traditional carriers, DSPs, that can't be in an ungoverned space. We have to find a way, both legally and in my argument, social contract. There has to be part of the social contract that for those people who want to engage in serious criminal conduct, and I'm talking serious indictable offences, there needs to be a way to be able to gain, intercept material in those serious cases because many of them begin to use those types of services. So this is a lot, in my view, an extension of the old Telco Act obligations and there were also obligations in the Telco Act under what's called Section 313, reasonably necessary assistance, which at the time obligated carriers to have to provide reasonably necessary assistance, and the words are important, to agencies to effect or do things necessary to help them intercept. It's necessarily opaque. There's no case law on it, and it needs to be because we don't actually always know what that assistance was, but it was lent by and given by, it was, remember, it wasn't a strict obligation, it was where they could do so to help effect that interception. So the way I describe it is it's taking what was real world telecommunication intercept out into the space of non-traditional carriers to try and obligate them and to bring them into a sense of you have a legal obligation, and we don't need to be tangled up right now, I'm just trying to get through the law, a legal obligation for certain serious offences to help us intercept those products where we know criminals go, gather and encourage and incite and facilitate serious criminal offences. So that's sort of the short, potted version.
Thank you, Rachel. That was a really helpful introduction. So we called this event Right or Privilege, Privacy of Communications on the Internet. And I might go to you, Ed, to just answer, is this about human rights? So to what extent do we have a right to privacy in our technologically mediated conversations?
Look, the default position has to be that you should be able to communicate privately with the people you want to communicate privately. International human rights law is crystal clear. It tells us that private conversations and communication should remain private. That general rule is clear from international human rights law, but it's also central to any liberal democracy like Australia. And that's regardless of whether the conversation is in person, by phone, by text message, or some other newfangled electronic means. So the right to privacy is vitally important, but it's not an absolute right. So limiting someone's privacy may be permissible, provided that any limitation is reasonable, necessary, and proportionate to pursuing a legitimate aim. I think Rachael has kind of pointed to the most obvious legitimate aim in this area. So if the Australian government wants to allow, let's say, the Australian Federal Police to listen in on a Zoom call or some other electronic communication between two people to investigate and deter a possible terrorist attack, in other words, if the legitimate aim is combating terrorism or protecting national security, unquestionably, that would satisfy the first of the two criteria under international law. But the second criterion is the more complex one. That's the more difficult one. In other words, the question is it reasonable, necessary, and proportionate to, in this case, protecting national security? So in theory, if the Federal Police were able to listen in on every Zoom conversation, were able to read every WhatsApp message, and let's assume for the purposes of this hypothetical that the AFP has unlimited resources and kind of a lot of ears, then that might enhance its ability to combat terrorism. And in fact, let's be clearer. It would enhance its ability to combat terrorism. The problem is that it would almost certainly fail the proportionality test under international human rights law. In essence, it would be a disproportionate restriction on privacy because far too many people who are entirely innocent, that is, people who aren't suspected of being involved in terrorism or any other serious offence, would be caught up in the net. They would have their communications no longer be private. And that's the problem. So to my mind, going back to your kind of core question there, Lyria, there's nothing in principle different about technologically kind of mediated conversations as distinct from kind of old-fashioned, more conventional communications, other than really scale. We have more of these communications. They can occur at much faster speed than was previously possible. And so in a sense, there's this huge wealth of data that is able to be conveyed between people. And the other aspect of scale that's really important is that we now have ways of kind of automating or partially automating the process of assessing that material and in a sense red flagging material that may be problematic for the sorts of reasons that Rachael laid out.
Okay, so I think it's fair to say we agree, at least on this panel, that certain agencies ought to be able to invade our privacy in some circumstances, at least once a warrant's been issued, and we can talk a little bit later about what those processes should be. To what extent should they also, so in other words, to what extent should agencies be able to demand that networks or software are designed in ways that make that possible? Rachael, do you want to start?
Sure. And can I just go back to Ed's point, and I think we are in agreement. There's just one point there. What Ed was talking about, and he's right, I agree with him. We all, security and privacy of information is important. I have every expectation that if we're on a call like this together, it should remain private. We're not engaging in anything that comes remotely close to an offence or anything like that. Absolutely. But what Ed was sort of hinting at was bulk surveillance. And in this country, we don't have bulk surveillance powers. If you want to read about bulk surveillance, certainly in the UK, there's lots of large publications about bulk surveillance and what it means. But here in this country, we have been really clear about that any surveillance done is both in real world and online is with a warrant, time-bound and proportionate and reasonable in the circumstances. So Ed is absolutely right. It's a bit like that Homer Simpson episode where, allegations the NSA listens to every call and then most people are just listening to people go, no, you hang up, no, you hang up, no, you hang up. That isn't how it is here, and it must remain so that it is under warrant. In fact, the AFP Commissioner Reece Kershaw has mentioned that and said this allows us to, in fact, this framework now allows us to be more precise in identifying, assessing and collecting secure and encrypted communications and records. I just wanted to mention that. The second question really was around should agencies ought to be able to invade our privacy? Is that the one you asked, Lyria?
No, so I'll try to rephrase it to make it a bit clearer. I think we agree that that agencies ought to be able to sort of access a particular communication in all the right circumstances.
Yeah, building in capability.
Should they be able to build in the capability? So you mentioned before in the case of the old-fashioned phone network, you couldn't sell a phone or a wire or whatever, all the bits of it. In such a way that it couldn't be tapped if the agencies wanted to. Yeah. Should that apply, if you like, for all different kinds of software apps and networks that we're seeing developing?
Look, and I agree, this is a really contentious point, and I should add that TOLA does not allow for assistance that creates a systemic weakness or backdoors. And I know there's been lots of debate around the fact that if they're created for one, it then can be used for others, and particularly in totalitarian states, or not necessarily totalitarian states and others. But I think it's a bit, if I could go back to reasonably necessary assistance, that is designed to be opaque. We don't actually know what that means, and nor will any of us find out. I think, again, whether it has to be created as a weakness is not ideal, but in some way to allow or affect an agency to have access to that material, and again, I'm kind of being deliberately vague because I suspect we will never know, is not a bad thing as long as it doesn't compromise security for all. You will probably have noticed in public commentary, none of the agencies come out and say how that is done or what they do, and for operational reasons they don't. But I agree, it is problematic when you start saying to, and this is unfortunately, I think, an unfortunate interpretation of the law originally, probably maybe needed more commentary around it, that the design is not there. They're not supposed to be designed inherently to have a vulnerability, because as I think many have pointed out, a vulnerability for one is a vulnerability for all. So I think it's really important that the law is clear here. They're not stressing, it is not stressing or not obligating providers and manufacturers to stop fixing vulnerabilities, to build vulnerabilities, or to make backdoors. How they actually get on is something we'll never know.
Ed, did you have any comments on that point?
It's such an important question, and I can't give a glib answer because it is exceptionally difficult. But can I try and reason things through a little bit from first principles and then maybe give a practical example, because I'm not part of a security agency and I don't actually know, but I think there have been some practical examples of how security agencies operate in this space that are worth discussing. So first principles. Let's forget we're talking about technology. Let's pretend we're talking about conversations in person between two people. The sort of thing that we're talking about there, if you want to make sure that the police can always listen in, that would be saying, okay, well, you can only speak to someone if you do it in this soundproof room where we've got a recording device, so that, if necessary, if you stray off course, we can listen in. That's the sort of principle that we're talking about here. Now, of course, I'm using it, describing this in very kind of sketched terms and being a bit melodramatic. But I guess what I'm saying is, when we talk about systemic weaknesses, in other words, when we talk about ways of designing communication systems so that you can have the federal police or the other security agencies listen in, what we're talking about is enabling, that sort of thing to happen, and that can be that can lead to essentially a disproportionate limitation on people's privacy. So let's take this to the tech context. I think one of the difficulties with this discussion that we've all had about systemic weaknesses is, what does it mean in practice? So one of the examples that was given was, let's say there's an individual who the federal police, on very reasonable grounds, consider might be having communications about committing a serious crime. And let's say that those communications, and it's a pure hypothetical, but let's say those communications are on a social media platform like WhatsApp, right? One of the most obvious ways of them being able to listen into those communications would be to require the owner of WhatsApp, Facebook, to roll out what looks like just a simple update on your on everybody's phone. So everybody who has WhatsApp gets this notification essentially that you've got an update, a patch. For everyone other than the individual, the idea is that it's literally just a security app, or maybe it's kind of like the equivalent of a placebo, so you don't get any change at all. But for that one individual about whom there's a reasonable suspicion, that individual will be essentially downloading a change to WhatsApp that allows the federal police to listen into their communications. Now, I'm trying to, I guess, set out a scenario that is as limited as possible. But even in that situation, if that sort of information starts to become widely known, then many people will say, I'm not so sure that I should be updating my apps anymore. You actually can lead to a situation where there is a systemic weakness, not perhaps for the reason that we initially feared, but because the integrity of that system whereby updates and security patches are rolled out, that the integrity of that system is called into question, and perhaps for understandable reasons, because if the community is not confident that process is done in a way that is in accordance with their basic rights, then they may well decide not to do patches, and we know that that's going to cause other security type problems. So I guess what I'm saying is, to me, the default position is building in those sorts of capabilities is incredibly dangerous, and to my mind, I don't see that on balance it's justified.
Rachel, did you want to respond?
Yeah, I do want to respond. Whilst I get Ed's point, it's enshrined that can't occur because that would be bulk surveillance. Whilst I acknowledge that might be a neat way of just targeting some individuals, the agency would be swamped with so much material it actually can't have for a range of reasons. So remembering that the law requires under warrant, targeted, time bound, you would then have to, and obviously I know we're in the dark a bit on this because we don't live in this world, but then you'd have to be applying for a warrant to encourage a provider to roll out an app for all its users because you want to target 10 people who you know are using WhatsApp to conspire on terrorist offences.
I think Ed's example was a little bit different, if I understand it. So I think what Ed's example was, let's suppose you have 1 million users of WhatsApp, right? And one of them is using it for drug deals or terrorism or something terrible. Yeah. That you have the 999,999 people get a regular security update, and only one person, would get the...
Oh, yeah, okay, well, yep, okay.
And I think Ed's point was that even though only one person actually gets the flawed update, that maybe another 1,000 people, or we don't know what the numbers are because this is all very hypothetical, will go, I'm not doing any updates on my phone anymore for any of my communication apps because I'm worried that, the government's spying on me, and they use updates as the way to make my device, to wiretap me. And so if I never update my phone, I'll be better off. And in fact, those people, by never updating their phone, as we all know, in cybersecurity, if you don't do the mandatory security updates, you do end up with a weaker system. So the argument, and Ed, correct me if I'm wrong, is that even though you're targeting one person, because of human psychology and fear, you might introduce a systemic weakness accidentally.
Sure, and that's more of a systemic human weakness than I guess if you're arguing. I get that point, and I get it, although there'd be people who think that now. But I suppose when you look at some of the judgments and some of the judgments around the people who do use these apps, you've just got to, I think, if that's the mentality of people who do sit there and worry about that, then get off all of it now, because I'd be more concerned about what Apple is grabbing from me or what I'm being pushed out in other ways, rather than maybe an app that's been laced or potentially laced. I get the point in theory, but I just think in practice, it's one I struggle with, because I see that on balance, when you see how the apps are used, anyway, they're effective to grab information. And if you think you're getting a dodgy app because government wants to target one or target you or target all, then you're going to have to deal with other challenges in this technological world. It might be able to happen, but again, I just think under law, it can't happen in Australia. And if you're worried about the one person, if you're not doing anything wrong, you wouldn't have to worry about that. You just wouldn't, these are for serious indictable offences, these kind of intercept warrants. They're not, not for pirating offences or things like that. So in theory, I get it, but in practice, I struggle with it a bit.
I mean, I think, that feels quite close to the idea of, privacy only matters to people who have something to hide. And I don't think that is quite where we want to be. And I don't think that that's what international human rights law requires. Again, if we go back to first principles, why this sort of thing really matters. It's very rare that I would quote Justice Cowan on the High Court, but one of the most lyrical judgments, I mean that literally, that I've ever read was one that he wrote in a case called Lena Game Meets.
Yep.
And he quoted at length Milan Kundera, the author of The Unbearable Lightness of Being. And essentially, Kundera was talking about the perniciousness of, in a totalitarian regime, having widespread kind of listening in by the authorities on people's private communications. And what he said was essentially, in private communications, when you're speaking to a friend or a family member or someone, you speak very, very differently from the way in which you might speak if you know that you're speaking publicly. He talked about floating heretical ideas, about, saying, kind of essentially speaking in kind of very extreme terms, not because you truly believe those things, but because that can be, an interesting way of having a conversation. And I guess it's a subtle point, but it's a really important point to my mind, that our liberal democracy does rely on people being able to be very confident that they can have those sorts of communications between them. And the whole point about a communication is you can be, in a sense, communicating with one other person. Let's say that sort of hypothetical I said before. You've got the one person who the federal police have reasonable suspicion is involved in serious crimes. Now, if you're intercepting that individual's communications, of course, you're also going to be intercepting at least partially what other people are saying to them. And so there are, I think, real concerns about that. So while on the one hand, I would agree with you, Rachel, that sometimes we can be a bit overblown in some of the abstract concerns that are sometimes articulated when it comes to privacy. I think on the other hand, we don't want to kind of pinball to the other extreme. And I do think we need to really be as respectful as we possibly can of why a concept like privacy is so central to our democracy and what's really important to us as a country.
Sure, and I agree with you that absolutely democratic principles, a right to private communications, a right in that Milan Kundera quote, a right to be able to speak freely and speak your mind. But as you mentioned earlier, it's not an absolute right. It is a right with carve-outs in certain circumstances. And I think even in the Independent National Security Monitor noted this can't be an ungovernable space. If I can just for a moment put some colour to this, and why I suppose I feel quite passionately about it, and that very conversation you mentioned, Ed, that people who are under intercept, all their conversations are caught. So it's not just the conversations with the co-conspirators, it is the conversations with loved ones, family members and the mundane. If I could just take you back to the death of Curtis Ching, who was a New South Wales police accountant back in 2015. And I think all of us and reasonable-minded people would all agree that that death was abhorrent. He was described by the court as a gentleman going about his business. He walks out of New South Wales Police, his place of business. He works there as an accountant to be killed by a group who described themselves as the Appleby Boys. And they were in total 1, 2, 3, 5 of them who were the offenders in the commissioning of this offence, with the one who killed the murderer, Curtis Ching, being 15. To bring some colour to this conversation, and who, while we talk about this right, and we're very passionate about this right to keep private communications private, they were under heavy surveillance and actively used an encrypted WhatsApp group called the BRICS. They used it as a form of counter surveillance to evade authorities, to conspire to commit an attack and share ISIS propaganda. When you read some of the judgments, and we did do quite a bit of work here, it is pretty compelling why I think groups like the Appleby Boys shouldn't be able to hide under the cloak of the privacy. And in fact, I have no issue with any of their conversations, the mundane and the private, being intercepted. But they killed Curtis Ching. They still remained conspired up until this point to kill him. They engaged in counter surveillance during this time, where the apps and use of apps was prevalent. And they continue to talk using these apps, not only to how they would plan this offence, but the fact that they all demonstrated no remorse for the killing of Curtis Ching. Similarly, there's a case in South Australia, and I won't go over all of them, where a family carer, Shannon McCool, in 2015, was sentenced to 35 years jail for his role as a head administrator of a dark web pornography site with 45,000 users around the world. Again, another case where someone actively uses the dark web and encrypted communications to obscure their criminal activity. So I agree that on intercept, others are caught. There are private conversations. I have no issue with that when it comes to people who are conspiring to commit criminal offences. I have no issue with targeted interception for those such as the Appleby boys, where, as you would be aware, even to talk about committing, you don't even have to have gone out and bought anything, to even discuss and to conspire to commit terrorist offences is an offence of itself. So I just the only reason I want to talk about that is when I think about Curtis Ching in that case, that could be any one of us. That could be anyone who is randomly gunned down simply because they might work at an intelligence agency, they might work for the police. And in that case, I struggle with where does it remain not private? Where should they be free? When does it tip over to when they can be on intercept? And I agree, my conversations should remain private. But at that point where we know that not everyone wants to have just innocuous or passionate conversations, these people tip over and use and actively know what apps to use, what apps to download and how to do it in order to evade. And I think that's why this goes to the heart of the targeted nature of these powers, that they are incredibly targeted and only used as necessary. They are not designed to make people nervous about rolling out and updating an app, and they're not designed to capture wide rings. And I think in independent, the IGAS, in the Inspector General's report, she often comments where agencies have inadvertently captured intercept material they don't need to capture and the ways they have to dispose of that, and they're not interested in that.
Okay. So I might, first of all, just to clarify a term, when you say someone is on intercept, do you mean that their communications are being intercepted under an order? Yep. So I just thought I'd clarify that sure. As a terminology issue. I want to go back to, and it was Ed, did you want to say something first? Oh,
okay. I think Rachel's made a really, really important point. I just want to explore a little bit, and then I'll hand back to you, Lyria. I think the point that you're really emphasising there is the point of targeting.
Yep.
In other words, I think we would all agree that anyone who would seriously consider a crime like the murder of Curtis Ching is someone who the authorities, the police and other law enforcement authorities, should be looking at very closely, and it would be a proportionate restriction on their right to privacy for their communications to be intercepted and for coercive action to be taken against them. So there's no disagreement about that. I guess where we have to be really careful is that this legislation is not ad hominem. It's not the legislation that is directed towards this specific group. It's directed much more broadly. And in fact, if we're talking about TOLA, TOLA very explicitly says that it's not limited only to people suspected of criminal activity. It is specifically broad enough, and this is the natural and ordinary meaning, and this is the intent of the legislation, that it can be used to intercept the communications of so-called innocent third parties. So people about whom there is no suspicion of any criminal activity, let alone serious criminal activity. So the concern is really essentially one of proportionality, whether the law and its application is in practice targeted enough. Now, it's true to say that the TOLA legislation has only been in operation for a relatively short period of time, so it's difficult to draw too many conclusions from the small amount of data that we've received so far about how it's used. But if you go back just a couple of years to the metadata legislation,
I knew that would come up at some point. It always comes up.
So when it was introduced, the government was very clear about the purpose for its introduction. Yep. I think the words that were used in the second reading speech and in the explanatory memorandum is that this is legislation that is designed and is aimed at combating the most serious crimes. And then it gave a number of examples, like murder and so on, right? And again, in terms of that first criterion and international human rights law, that obviously, is satisfactory in establishing that first criterion. But then you have to look at its operation in practice. And we know, I don't have the most recent data in front of me, but from memory, over 15% of the metadata interception that has occurred under that legislation has been for literally the least serious crime. There's things like chasing up parking fines, that sort of thing. And I mean that literally. And so one of the kind of concerns, so when we talk about targeting, we mean in two ways. Targeting only those people who are seriously involved in crime, so they're targeting the right people, but also targeting the right problems. And I think one of the concerns that we have is that we don't always have a great record at making sure that those statutes that are passed and are explicitly justified to target the most serious crime don't then bleed into looking at much less serious crimes for which the justification on limiting the right to privacy is much less strong or maybe just insufficient.
Okay, so it's a really good long discussion there. I really encourage everyone who's listening to ask questions, and I thought I might start by going to a couple of those. So there's two that are slightly related. So we had the comment earlier, if you've done nothing wrong, you have nothing to worry about sort of idea. And so one of the questions is COVID safe a good example of a small proportion of the population being skeptical about being spied on? And then another question relating to the COVID Safe app, which is, has anyone considered the distribution and use of COVID testing data? Well, not the COVID Safe app, COVID testing data, sorry. There's anecdotal evidence that this COVID testing data is shared widely, including in hospitals and aged care. How is it being shared, and does anyone know? So there's, I suppose, that's slightly outside the national security context, but both of the questions in relation to COVID, I suppose, give this idea of, there is sort of a level of loss of privacy associated with public health, which is of course a different objective to national security, but not unrelated. Is this something we need to be worried about? Are people more worried than they need to be?
So if I could take the COVID Safe app one first, because we were heavily involved in the independent testing of the COVID Safe app. For a couple of reasons, I've always said publicly it's a very blunt set of data. People need not be concerned, and there's quite stringent legal caveats to use of this data around the fact that it can be used in very limited ways. Government can't get to it. Again, I might add, we give up, if you're on an Apple device or you have an Apple connected home, you give up far more data to Apple every day of your life than you ever give up with the COVID Safe app. Literally, COVID Safe app will have your name, might have your age range if you've given it, and it will be who you've pinged in the vicinity for the last 14 days and nothing more than that. It is, to be blunt, not of use to agencies because, as Ed rightly pointed out, if they wanted to, they could get metadata, which is far more precision targeted about the web of way of life. And moreover, they could go and get a warrant and get far more effective data. It is really a very unhelpful data set in the scheme of things. So should people be worried about COVID Safe app? No. Was it, though, rightly so in the point, was it sort of a bit of a litmus test of mistrust of government? Absolutely, because you had My Health Record. Government don't always have, always the best track record when it comes to securing data. And I was pleased on one level to see people taking an interest in their privacy and data. Well, I loved the fact people were actually alive to this risk. So I found that really good. But what I found a little bit mildly irritating was that we don't give a second thought to the apps we accept, the data we pump out, and the data we freely give to unregulated large multinationals who slice, dice and sell it. That was my big line, is you should be more concerned about what you're giving up when you accept updates or you engage in different activities online. So that's sort of my position on the COVID Safe Act. I'm happy to let Ed take the testing data one. I think it's a relevant question, though, around how concerned, what happens to that data, where does it go, and again, who gets access to it?
Look, as Human Rights Commissioner, I feel like my job is professional warrior. So I feel like I can walk and chew gum in terms of numbers of worries to have. So to my mind, I understand what you're saying, Rachel, which is that we should be concerned about, perhaps more concerned about the way in which we hand over personal information to private companies than the government. But I would say, why only limit ourselves to one worry? Why not be worried about both? And I say that sort of half jokingly. I guess maybe there's a positive and a negative comment. I think you're absolutely right, Rachel, in saying that the government was working off, I guess, a basis of limited trust in terms of the community's perceptions of how safely it would keep people's personal data. And so I do think it was quite responsive to input from a range of stakeholders, including us. I mean, I'm not saying that all of our advocacy was accepted, but some of it was. And I think it did include some really important protections in the legal framework that applies to COVID Safe, the app, that are really important. So it would be prima facie, I'm not expressing a kind of a legal judgment here, but it would be prima facie impermissible to share their personal information in the way that was just described, across the health system. That's just not permitted under the legislation. Now, the second point, which is a really critical one, which is that of course, the COVID Safe app, because it uses personal information, it does limit the privacy of anybody who is caught up in it. Now, we can have a debate about how much it limits people's privacy, but let's put that to one side for the moment. Justification for limiting people's privacy is essentially that it will enable people to stay safe in a pandemic. It will give people critical information as well as the health system more broadly, that will enable people who might have tested positive to stop themselves from infecting others. And if you've come into contact with someone who's tested positive, then it will allow you to take sort of evasive action to protect yourself and your family, right? Now, the point is that then it must do what it sets out to do. In other words, the app has to work. And I guess what we are starting to see is some kind of relatively early analysis that suggests that perhaps it doesn't work as effectively as it might. So if let's forget we're talking about the COVID Safe app for a moment. Let's say we're talking about some hypothetical app. Let's imagine it was completely ineffective, but it only limited privacy a little bit. It would still be unacceptable, right? It's got to work in order for any limitation on privacy to be justified. And in fact, we would say here, it's got to work pretty effectively. Now, I think it's completely acceptable for government to improve the app as it goes. But what we want to see is really rigorous and independent evaluation of the app over time to make sure that any limitation on privacy, and there is a necessary limitation on privacy, that is justified by the fact that it's actually helping people keep safe in a material way. You might be still on.
Yeah, no, yep, sorry. Okay, so I said we'd come back to the issue of warrants and the process through which all of this occurs. And I'm not going to ask either of you to give a section-by-section analysis of that process. But I might just ask a couple of questions sort of related to that. We had a very specific one, and Rachel, I do not know if you know the answer to this, which was what was the gang doing before the murder of Ching to warrant very close surveillance? So that could be a useful in terms terms of explaining the kinds of things that lead to surveillance taking place. But I know that there's also been some recommendations about changes in that process that were made by the Independent National Security Legislation Monitor to sort of make that a little bit more rigorous. And I'm wondering, I suppose, what, first of all, what has the process been? For example, in the case of the gang for the murder of Ching, if you know that answer. But beyond that, is the current regime sufficient, or would, what would you each say about the specific recommendations of the independent monitor on that?
So to answer the question around the Appleby boys and what they were doing to warrant surveillance, they came to attention to the authorities via family connections. And then once the family, and we're talking serious sort of family connections, and then once they were that, they were then under intercept or under warrant and investigation, because it was then revealed that they were all radicalised ISIS supporters and that they were conspiring to carry out some terror attack, a homegrown terror attack. So they then became under surveillance, and it became clear that they were engaged in a whole bunch of criminal activities. So this wasn't certainly, they were, also there was another member who was a member of BRICS forum. So there were a couple of forums involved, and then it was basically they had a lot of connections both to ISIS and Travel to Syria. So they were all interconnected, and there were earlier raids with other family members. So it wasn't just a random sort of investigation. It came to the attention for a range of different reasons at the time. And that's how they then worked out that they, obviously until after the event, that they knew something was going on, but unfortunately too late.
Okay, Ed, did you want to comment on the second sort of part of the question in terms of the recommendations for changes in the warrant process?
So Independent National Security Monitor, I know, has made a range of changes. I think, to be honest, I think there's been double lock has been one of the changes proposed. So that's not only that it's not the head of agency, it goes to a judge, preferably, or a member of the AAT, and also whether there's an independent commissioner too, which is similar to what they had in the UK regime. Look, to be honest, I think there's always a trade-off here too, that when you want to give agencies and law enforcement more what is perceived even to be more intrusive powers, even if they aren't necessarily any different to old style powers, you do have to invite the public into that narrative, and you have to build public trust and integrity. So it's really important that all law enforcement or anyone seeking to use these powers and the product that comes out of them, the intercept material, that they have to be brought along on the journey, because if they're not brought along on the journey, as yet, people become suspicious. They think either they're under surveillance, they don't understand. So it's really important that if there are mechanisms that help increase public trust, help build confidence in the system. We may not actually know what the actual detail is. That's never going to be in public unclassified reports. But I think generally speaking, we feel more comfortable if we feel it's not always, and this is absolutely no disrespect to current politicians or commissioners or heads of agencies, but if you do feel sometimes it's a non-elected official, if it's a member of the judiciary or there's other oversight, we will feel more confident that where there are perceived miscarriages of justice or perceived setups or whatever it is, that there's an avenue, that there's an independent avenue beyond the organisations who have a vested interest in pursuing the investigation. So I think I'm not opposed to the double lock, but I think there are many already existing safeguards and legislation, because the three types of notices under TOLA cannot occur without a warrant and a time-bound targeted warrant. But I still think, similar to the old regime they had in the UK, which was an interception commissioner, the powers of the then interception commissioner were they could go into any organisation that was bound by the Act. They could ask to see ongoing warrants, ask to see previous warrants, go in. They could, almost like IGAS today's, they have powers of a standing royal commission. I think that's a good thing, because I think this is not going to diminish. The powers are not necessarily going to be pulled back. If anything, I can see over time we may want more and more what perceived to be intrusive powers. But I think as a society, we have to get to the point to accept it can't remain an ungovernable space. We simply, I think, all accept, as even Ed said, we accept there are carve-outs for particularly egregious criminal behaviour, but at the same time, as Ed said, the proportionality that has to be balanced with oversight mechanisms The only slight caveat to what Inslam said and the recommendations about double lock and another commissioner, we just have to make sure that then that isn't compliance for compliance sake. So you can, what could happen is you could spin up all sorts of parts of these agencies that just are in compliance mode, that it really will have, and I'm not suggesting they don't take their obligations seriously, but it will really be genuine oversight and compliance that gives the public assurance that it's not just a tick and flick exercise at the agencies. I think that to me seems like a good step forward.
Ed.
So I think that there are sort of three key protections here. The first is the most fundamental one, and in a sense, it's quite a difficult one for us to discuss, but I don't think we should shy away from it. And that is to always ask the kind of threshold question: are these powers truly needed? The Chief Justice of the Israeli Supreme Court famously said a bit over a decade ago that the thing about being in a liberal democracy is that you know, the security services, your police and so on, have to fight with one arm tied behind their backs. So they're given good resources, and that's really important that they be given good resources. But the answer can't always be, we need to give them more intrusive powers. Sometimes the answer has to be, no, we've got to kind of help them to be as diligent as they possibly can with their existing powers, even noting those limitations. And I think too often we as a country skip over that threshold question, particularly in the counterterrorism or national security area. The second, I think, protection is making sure that the legislation is framed in a way that there is as few unintended consequences as possible. I'll refer to one good thing, right? Like, so when the parliamentary committee process was reviewing the bill before it became a law, they pointed out that while it was framed to be, protecting against the most serious crimes, actually it was also possible, for example, for AUSCL to use the scheme in relation to, quote, the interests of Australia's national economic well-being. An incredibly broad concept, right? Now, that was taken out of the bill before it was passed, and that's a good thing, but we would still say that the concept of serious crime is actually still probably broader than it needs to be. So I guess what I'm saying there is framing that in a way that it will pass the proportionality test is critically important and requires some restraint. And then the third one is exactly what Rachel's talking about, making sure that there are really effective integrity oversight mechanisms in place so that the operation of the law is entirely consistent with, the kind of claimed limits of the law when the bill is going through Parliament. And so that means that more could be done, for example, to make sure that all of the powers, the truly intrusive powers, can be exercised only by a proper judicial warrant process and so on. So I agree with what Rachel said there.
Okay, we've only got another few minutes. So what I'm going to do is I'm going to take a few of the questions and sort of put them together, because I actually think there's an interesting link between them. And the link is really around, public engagement and how much the public knows or doesn't know about how all of this goes on. And obviously this is a challenge because the agencies can't tell you everything. But, we have one question which came actually out of Ed's summary of the data available on the operation of the metadata legislation. How important is facilitating public scrutiny of the operation of legislation with worthy aims after it's in operation? So to what extent can the public understand what's going on? But then there were also some other comments and questions, I suppose, which sort of suggested some real concerns about what might be happening, right? So one comment, these systems are presumably monitored by public servants and AI. What audit authority watches them? The UK, after post-Snowden reviews in 2015, enacted the Investigatory Powers Act. Among other things, this clearly avowed the practice of bulk interception, wherein communications are screened before certain of them are selected for further examination under warrant. Given its Five Eyes commitments, it seems likely Australia also screens communications on a bulk basis. And another one, supposing targeted work is carried out by authorities to only those suspected of committing a crime in the present, what is there to prevent future governments or otherwise acting on the information gathered in the past? There is no guaranteed forward secrecy once secure communications are no longer private. And the reason I group those together is I think they come back to that public engagement and potentially not, you know, the public concern about, you know, in a sense, terrible sort of scenarios, partly because we don't know. So I was wondering if you had any comment on any of those in particular, or just generally the idea of, you know, public engagement and transparency.
So I think, yeah, they're all really interesting questions. I think I think even Islam's highlighted that the public don't and always can't always know what goes on. So I think I'm not saying that agencies should say just trust us, but I do think it is inherent, and every intelligence agency around the world will say, we cannot tell you what we do for operational reasons. We can tell you certainly after the event, and it may become public, but there is an element where, unfortunately, we do have to rely on the good people who are in those agencies, hopefully doing the right thing and abiding by the law. We just can't have it any other way. In terms of metadata, absolutely. I sat on the sidelines of that and was involved in some part when I was in my former life. Absolutely, that doesn't help it when it's not well explained. I think part of the obligation is for public officials and our politicians to explain what they want and why. And that does help, again, to public trust, to have clear definitions of things, and rightly so, as Ed pointed out. You know, serious offences just used as that to define it clearly so people know, what do we mean? Do we mean a 7-year minimum indictable offence? What does it not mean? That's really important. Having politicians explain things in plain language and not getting confused about what might or might not be caught also helps build public trust and integrity. I think and as a former lawyer, I can say this confidently, we don't have bulk interception in this country. I know what it looks like in the UK. We do not have that. Are they sitting, you know, NSA like in agencies here, listening to our phone calls? No. If they are, it's illegal, and good luck to them, but it's illegal there. As to Ed's point, there aren't enough ears to listen. We do have to have some faith at some point that they do abide by the law. And again, that's what IGAS are for and others. So I accept that, you know, there may be some concerns about what they do and don't do, but there is a point with all agencies that we won't know, we will never know. What we do know is when they do thwart serious terrorist plots and things like that. And that's when we do know. And I think the head of the AFP and and ASIO and others said that they have used these TOLA, and they have used under TOLA the different notices to thwart, you know, many, I think it was up to 14 plots. They have used them to effect, and whilst I can't go into what they are, they do use them. So I'm not saying just trust us works, but at the same time I'm saying, but I also think it's incumbent upon public officials and politicians to open up a bit more about what they mean, why they want it. To Ed's point, if you do want more intrusive powers, you have to also bring the public into that narrative and be really clear about the trade-offs and why.
Ed?
So very quickly, I think what we have become a bit accustomed to since 2001, since September 2001, is this kind of almost constant process of reform which involves new powers. And I'm not inherently opposed to that. I observe that we've passed more, you know, national security legislation than pretty much any other liberal democracy in the world, and that's curious. But there's not a proportionate kind of focus on how those powers are being used, right? And I think to Rachel's point, absolutely, it's really important to get a really clear understanding of when they've been used very effectively to do important work, because that helps us identify where some of those laws might be absolutely necessary. But it's equally important to perhaps focus on areas where perhaps they haven't been used as effectively as they were intended to be used, maybe not in as targeted a way, may have been misused, or maybe not used at all. Because, of course, sometimes that can be an indicator, not a perfect indicator, but it can be an indicator that maybe the legislation is not needed in the way that it was anticipated. So I guess what I'm saying is, as much as we focus on kind of, you know, constant reform in this area, we also need to have a similar focus on how the existing laws are operating, how effective they are, and what changes need to be made.
Thank you. And I think we have to wind things up now. So I'd like to thank both of you for a really rich conversation on this important and controversial topic. You've both been amazing, given some really clear explanations on really tricky stuff and clear arguments. So really appreciate both of your involvement. And also wanted to thank the audience for listening, whether live or later. and thank all of the co-hosts again. We won't go through all of that again. And Marina, I think you wanted to announce a subsequent event. Yes, or there was a slide?
Yes. Thanks, Lyria. I think there is a slide. Echo what you said. Thank you very much, both Rachel, Ed, and of course Lyria, for a very engaging conversation. I could have listened for a few more hours. Experts and a delight to listen to. Just one event that I like to mention, it's a Tech Futures event next week. We have 4 technologists speak about what they think the future projections are for technology here in Australia and beyond for the year 2040, to give you some context of where laws might have to catch up to and what we can build in the design of those systems. So please join us, and thank you again to our panellists. Have an enjoyable evening, afternoon, morning, wherever you're found, and see you next time. Thank you.
Thank you.